Oh yay, oh yay, oh yay. The Honorable Appellate Court, 5th District, State of Illinois is now in session. The Honorable Justice Bowie presiding along with Justice Moore and Justice McKinney.
During the 2020 COVID pandemic, Democrat Governor J.B. Pritzker ruled Illinois by fiat. His COVID response was often the most draconian in the United States, including lockdowns, closures of businesses, churches, and schools. But what many people don't know is J.B. Pritzker suspended many elements of the Illinois Open Meetings Act through executive order. The intention of the Open Meetings Act is to prevent government from having secret meetings and from conducting business behind your back and without your knowledge, especially when they're spending public funds. The effect of J.B. Pritzker's executive order was that many local governments would no longer meet in person under the guise of COVID, and instead they would meet virtually or on the phone. On March 21st, 2023, the Illinois Appellate Court's 5th District met to hear oral arguments about J.B. Pritzker's suspension of the Open Meetings Act via executive order. When Madison County moved to terminate Rob Dorman and Doug Hume, they did so in virtual meetings after J.B. Pritzker's executive order suspending the Open Meetings Act. The Madison County April 16, 2020 meeting violated numerous Illinois laws, including not publishing the time and location of the meeting 48 hours beforehand. On top of the hastily called meeting was the fact it was one of the first virtual meetings for Madison County, meaning members of the county board were calling in via phone and video conference and were not physically present to have a physical quorum. Members during that meeting were texting each other. They were also introducing resolutions without prior notice that weren't even written or read. The public comment during that meeting was submitted by email and read by the county clerk. The key issue before the appellate court is, can the Open Meetings Act, which was passed by the Illinois General Assembly, both houses, and signed by the governor, can it be undone by an executive order by J.B. Pritzker? Madison County Defense Counsel points to the Illinois Emergency Management Act for J.B. Pritzker's authority to suspend the Open Meetings Act. It is obvious that allowing the Illinois governor to suspend state law for an emergency is problematic. The question is, did the Illinois Emergency Management Act allow J.B. Pritzker to suspend Illinois statute? And the answer is overwhelmingly no. If the Illinois governor can suspend the Open Meetings Act, what else can the Illinois governor do? The Illinois Emergency Management Act was designed for state agencies to streamline the flow of goods and services to disasters. The Illinois Emergency Management Act was not designed for the governor to pick and choose laws to suspend or to get rid of. The Illinois state COVID response, led by Governor Pritzker, led to an overreach in many areas. Businesses were closed, churches were closed, schools were closed. Many aspects of daily life in Illinois were changed forever. The result of J.B. Pritzker's executive orders can still be felt today in 2023. The overreach was overwhelming. The case before the 5th District today is a very important case for Illinois citizens to prevent what happened back in 2020 and 2021 during the COVID pandemic, when life itself stopped in Illinois and we were locked down. The result of suspending the Open Meetings Act was that Hume and Dorman entered a termination hearing that they were not notified of, and they were only able to attend via their own home via phone. They were never able to face their accusers, to see the evidence against them, to be confronted by any charges that they could refute. And the public missed out on an opportunity to view its government conducting business and doing it properly. This case is important for Illinois because J.B. Pritzker put our democracy on hold in 2020. And will we allow another Illinois governor to suspend the laws of this state? Therefore, it's important for us to stay vigilant and hopefully here the appellate court rules very clearly that J.B. Pritzker and any Illinois governor cannot suspend Illinois statute based on an executive order, no matter what the reason.
The only reason that this meeting was held virtually, and it was allowed to do so on the basis of Governor Pritzker's order 2020-07, in which he waived the Open Meetings Act requirement of being physically present.